station, 1370 WOCA.
Ocala.
All right, 25 minutes before 11 o'clock. Thank you for tuning in. There's so many things in the world when you're listening to the news that have to do with courtrooms and legalities, and it's just one of those never-ending things. That's why it's always good to have an attorney that we can ask questions of. John Fuller does this for us each week, and today he kind of ran in here at the last minute. Let me give him a chance to catch his breath. He's an attorney with the law firm of Fuller and Fuller, and he's here to answer your questions today on Wednesday, May 15th. The show is called Legally Yours, and the phone number is important because that's how you get through. It's the WOCA Climate Control Source Hotline, 622 WOCA. Good morning, John. How you doing?
Good morning, Larry. It is especially nice to be here today since I thought I was going to be held up, but it's great to be here, and I appreciate all of our listeners. I was reminded as I literally got held up at the office and thought I was going to be late and was rushing. And there's a extraordinarily good lawyer named Roger Dodd. He practices in the South. He's out of Georgia, has an office in Jacksonville, has authored a book that is probably the best book I've ever seen on the science of cross-examination.
Oh, wow.
And he is truly extraordinary and a nice guy and a fella I've worked with. And he sometimes works on court TV as a commentator for various trials, and has on a much broader basis and grander style a court TV program that's not much different than what we try to do here locally at our level. And Roger tells a great story about how when he goes to the studio, they send a car to pick him up. And when he walks in, they announce when he's ready, the talent is in the studio. And he said, boy, that he kind of felt pumped up about that. They were referring to him as the talent is in the studio.
There you go.
And he said, but if you want to stay grounded, just work in television, because after the show is over and they no longer need him and they're taking him back to the airport, they call in and say, the load is in the limousine.
Oh,
so in the twinkling of about a 30-minute show, he goes from being the talent to the load. So I'm not sure I'm a talent, but I hope I'm not a load. But anyhow, it's great to be here. How have you been?
Good. Last Friday we were at the Student Media Festival, and the judge, Sarah Ritterhoff Williams.
Very, very good judge. Very nice.
She was one of the presenters.
That's great.
And I had never met her before. I knew the name because she's in the news. I had no idea that she was an attractive lady. I just didn't know. I don't know what I thought she'd look like. But anyways, it was a nice revelation for me to get to meet her. So.
She is one of our very, very fine circuit judges. We are quite fortunate to have wonderful judges here in Marion County, county court judges and circuit court judges. Judge Ritterhoff Williams was a prosecutor for many years before she became a judge.
Yes.
And I think she is doing an excellent job. Being a judge is a difficult position. They have, a circuit judge especially, probably has more power than any other single position in the state of Florida. They handle cases involving individual citizens' freedoms. They handle cases involving major property issues, large amounts of money damages in civil cases, and things involving children in family law cases.
Yeah,
all the things in human existence that are difficult decisions. And when they make a decision, there is usually, not always, sometimes their decision will be a win-win, but it's an adversarial position when you're in trial, and there's going to be a winner and there's going to be a loser. So it means that 50% of the people that you deal with every day is going to be, if not mad, at least unhappy with what you've done. Yeah. And so it takes a special temperament to be a judge, and I commend all of them and congratulate them, and I'm grateful that we're fortunate to have good ones here, because as a trial lawyer trying cases down in the in the pits, so to speak, the most delightful thing that can happen is to have a knowledgeable judge with good judicial decorum who treats people with respect and courtesy, but with firmness and resolve, and who has read the file, knows the law, and gives the lawyers the chance to put on their cases and then promptly rules. And that's, in my opinion, that's the essence of a good judge, and we have a number of them here.
And you have a phone call, John. Good morning. You're on the air with John Fuller.
Fuller.
Good morning.
You're certainly right. I had the opportunity to work with, when I was doing case management, social work, I had the opportunity to work with Judge Sawaya before he was promoted and left the area, but and it was great working with him. I did the Baker Act for seniors and stuff like that.
Thank you for your service in that. That's a very important area.
And also I had the opportunity. I served on the Foster Care Review Board for about 5.5 years, and at one time Judge Singbush was involved with that.
Yes, sir.
And I enjoyed, those are two judges that I had some.
Well, my comments were across the board. Judge Sawaya now, of course, as you mentioned, is an appellate judge on the 5th District Court of Appeals and sits in Volusia County and hears only appeals. But he is very scholarly, very knowledgeable, was an excellent trial judge, was an excellent lawyer before he became a trial judge, and is an outstanding appellate judge. If you read some of the opinions that he's authored, they are all well-written, well-reasoned. He's a very, very good legal scholar and writer, and I know he takes a lot of pains in trying to analyze the law and come up with opinions and decisions that treat people fairly.
Yeah, I know a couple of judges that work down there in that area with him, too. But my question is, recently, I guess the Supreme Court in the state of Florida here, the judges decided that they were going to allow, lawyers that are not judges to hear these cases that involve foreclosures and stuff like that. And I was wondering what your opinion was in regards to that. I'll hang up and listen to you, and I always enjoy listening to you. Thank you.
Thank you very much, and thank you for taking the time to call in, and thank you for your comments. What happened, and I don't do foreclosure work, so I may not have all the details exactly correct, and I give a disclaimer.
Yeah, I'm glad you asked that question. That's a good question.
That is. What was happening is, as everybody knows and has experienced at every level, our community, our country, went through a painful economic recession. I'm not sure that I'm smart enough to know the difference between a recession and a depression, right. But theoretically a depression is supposed to be worse, and I can't imagine it getting much worse than it was in 2007, 2008, 2009 for people in all levels of socioeconomic stature. And as a result of that, the court system was inundated with foreclosure actions, thousands of them. Yeah. They were backlogged. The whole system was gridlocked. And so exceptional circumstances sometimes require exceptional remedies. I'm not personally familiar with how that process works or what they did, but I think that it did give relief because it allowed our circuit judges to concentrate on those types of cases. For instance, if you're sitting in jail waiting on trial because you've been charged with a serious felony offense that you are not able to post bail on, or some charges where bail was not set, and you're waiting for your case to be tried, and the court is backlogged because it has 4,000 foreclosure cases, they had to reprioritize. And so I think that is what the reason for it was. You know, a lot of people can be appointed lawyers as special masters, and they move the cases through, review the paperwork. There were so many foreclosure cases that banks were filing foreclosures, and they had lost the promissory note. They couldn't even prove their case.
Wow.
And so somebody had to be a referee on that. The special or general masters then make findings of fact and recommendations, and ultimately is reviewable by a circuit judge. So I think it had sufficient checks and balances, and we've kind of gotten through that. So I know we have another call.
Yes, sir. Good morning. You're on the air with John Fuller.
Yes, good morning, Mr. Fuller.
Good morning, sir. How are you today?
Very good, thank you. Speaking of judges and that, is there an age limit on a judge that he's more or less forced to retire?
My recollection is, and again, don't hold me to this because I've never been a judge and
right.
don't have any wishes to be a judge, because it takes special skills and mindset, and I don't think I'm particularly well suited to be a judge, so I've never wanted to be one. But 70 is my understanding of the mandatory retirement age for a judge as far as being an actively serving judge. But we have another category that is very helpful to our judicial system and to the citizens who need the services of the judicial system. You can become what is known as a senior judge. We have two very excellent senior judges here in Ocala, Judge Musley, Judge Victor Musley, and Judge William Swigert. They continue to hear cases, and I had a case that was going to take several weeks to try, and to get on the docket of one of our other judges who were so busy, it would have been a very long period of time. But the lawyers involved in the case all stipulated that we would like to have a senior judge appointed. So the administrative judge appointed Judge Musley. He was able to devote 2 weeks of time and did a very good job, heard all the motions, was familiar with the case, and proceeded right on with a 2-week block where it would have taken maybe 6 months or a year before it could have been put on the docket. Because a 2-week trial is a rather unusually long trial. Most trials take a few days.
Yeah.
So we do have senior judges. I think Judge Carvin Angel is also doing some senior judge work. He's a retired judge.
Right.
And so I know here in Ocala, Judge Swigert and Judge Musley are doing it. They were both outstanding trial judges for many years. They retired at the mandatory age of 70 and have continued to serve this community as senior judges, hearing cases that other judges could not work into their docket, either because of the time or the complexity, or the congestion of their dockets that made it very difficult to let one case take 2 or 3 or 4 weeks, which occasionally you do have those cases.
Yeah. Speaking of the age 70 now, when a citizen becomes 70, I believe you're not eligible, or you don't have to report for a jury duty.
I think you're right about that, although I have not read the statute recently about it, but there is a point where you have an automatic right to be excused if you are a mother with young children, if you're in certain, like the medical profession, if you're over a certain age, all you have to do is say, I don't want to serve, and you're automatically excused. Although I've had juries with many of our citizens in this community who are over 70, and they did a wonderful job as jurors. They were alert, they paid attention, they followed the evidence that was presented, they understood the arguments, and I thought in the jury trials that I've had, they all were exceptionally motivated and tried very hard to see that they did a good job and do it fairly. I've also had trials where jurors in their 30s dozed off and went to sleep after lunch. Age doesn't always determine one's abilities.
Yeah. Do you think, like, when you reach age 70 and you'd still like to serve the community and as a juror, and that would you like contact the courthouse or something and say, keep my name active or something like that?
No, I think what happens, and again, I'm not sure on this, and you could call the clerk's office or actually the supervisor. No, it would be the clerk's office. Okay. But if you are a licensed Florida driver, okay, your name is in the database that makes you eligible to or potentially available to be summoned for jury duty. Mm-hmm. You'll get a questionnaire when you get your summons, and in that questionnaire, it will have a space where you can check that you are over age 70 and desire not to serve, and you send that back, and your name is automatically taken out of the pool, if you will. Yeah. However, if you desire to serve and don't want to exercise your automatic right to be withdrawn, you simply show up at the appointed time and place, and they will put you in the jury pool. Yeah. You may or may not get called into to serve, and you may. One of the questions that they ask every juror, and it should not offend anyone. It's not meant to be personal, but they will ask people. Do you have any problem hearing? Do you have any problem with vision? Right. Do you have any issues that would distract from your ability to be fully cognizant of what's going on and to focus on the evidence and to provide your full attention to the case? Yeah.
Well, I think it's a great privilege as a citizen of this country to do that service. And I served on 4 juries, and
that's wonderful.
Each one of them was exciting. It was wonderful. I couldn't wait to get there the next day.
well, I thank you for your service. The system won't work without people serving, and I have served on a jury one time. I was summoned and actually got picked and actually served as a juror. And I agree with you. Even though I had tried 50 or 60 or 100 cases by that time, it was a marvelous experience for me to see the system functioning from the eyes of the jury box. Right.
It certainly was. Okay, well, thank you very much. It was nice talking to you.
Thanks for calling.
You bet. Bye now.
If you have a question for John, the number is the WOCA Climate Control Source Hotline, 622-9622. Can I ask a question from the news?
Absolutely.
O.J. Simpson is in the news. He says he wasn't given the information that he could have had a plea bargain.
Yes, he is, and that's a great question, Larry, as you always come up with, because our Constitution gives every citizen some extraordinary relief powers with what are called extraordinary writs. And one of those is the writ of habeas corpus. It means literally in Latin, produce the body. And when you are in jail, even though you have exhausted your appeal, if you feel that there are extraordinary grounds that were not properly considered or properly raised, you may petition for a writ of habeas corpus at any time. A judge will review the writ and will determine whether or not it is legally sufficient on its face to establish a prima facie claim that would justify the issuance of a writ of habeas corpus to address your grievances on the merits. O.J. Simpson did that. He filed a petition for writ of habeas corpus on 22 grounds. The judge reviewed the petition for the writ and determined that 19 of those 22 grounds met the judicial standard that he was entitled to an evidentiary hearing.
Wow.
One of those issues was whether or not he had effective assistance of counsel. And the Sixth Amendment of the Constitution says that every citizen is entitled to effective assistance of counsel. Our Fifth and 14th Amendments have said that those are fundamental due process rights, both at the federal level and at the state level. And if you do not have effective assistance of counsel and you go to trial and you are convicted and subsequently a judge determines that you did not have effective assistance of counsel, that is sufficient grounds for them to reverse the conviction and remand the case for retrial with a new lawyer.
Here's what it looks like from this layperson's point of view. He went to the trial and he said, "I'm not guilty." The jury disagreed, said, "No, you are," and put him away. Now he's coming forward saying, "Wait a minute, I want to have the opportunity to have a plea bargain," which is basically saying, "I am guilty, but..." Am I right about that?
Well, I think you raised some good points, and I don't think it's a question of being right or wrong. And I wish I had had time this morning to have read the article in detail. I saw it. I skimmed through it.
Yeah.
Basically, as I understand it, what he is saying is that the prosecutor offered his lawyer a plea bargain, and he was not given the opportunity to weigh whether or not a plea bargain would be in his best interest.
Mm-hmm.
Many people negotiate pleas in criminal cases. They plead no contest or nolo contendere, which means we're not contesting the charge, but we're not admitting that there's a factual basis. But as opposed to running the risk of a jury trial, and no one can predict what a jury could do, and O.J. Simpson certainly had a lot of notoriety, whether deserved or not, whether accurate or not, or whatever. You've got to at least acknowledge that you'd have to be, it would be unusual that you had not heard about O.J. Simpson and what went on with him, and many people in society had strong feelings about him. So that raises certain questions of your ability to have an unbiased, fair trial. Just because we live in a world with 24-hour news, I remember when that trial went on, I thought Geraldo Rivera was going to make a career out of that case because that's all there was.
This one was just the...
But this was the one in Las Vegas, but when you talk about, well, he pled not guilty, and now he's talking about a plea bargain, isn't that inconsistent? Well, it may be, but many people who are not guilty plead to offenses not as an admission of guilt, but as a plea that is in their best interest. And he was looking, as I recall, at a potential jail sentence of between 9 and 30 years, which ultimately he got. He's now served 4 years of it. If a prosecutor comes to you as the defense lawyer and says, "Listen, there may be some deficiencies in my case. I'm not sure I can get a conviction, but I'm reasonably sure I can. But rather than going through a trial, I'll let your client accept a plea to a lesser offense or a lesser sentence, and instead of going to the jury trial and running the risk of a all or nothing, a 9 to 30 year sentence,
explained a few weeks ago,
or you plead to 4 years and you'll be out at age 65. I mean, he was 60 at the time, or 61. Well, a 30-year sentence for a 60-year-old man is pretty much a life sentence.
That's right.
And so rather than take the risk of maybe spending the rest of your life in jail, it may very well be, and I've had literally hundreds of people say, "I'm not guilty, but I can't run this risk. It's better for me to take a plea bargain and accept, say, 4 years in jail, which I can do and reasonably expect to come out at age 65 and still have a life left that has meaning and quality and health and so forth, rather than, even if I live to 90, what kind of quality of life can I expect at age 90? So many people plead to cases, Larry, but that doesn't necessarily mean that they, or if they plead no contest, they're specifically saying, "I am accepting this plea," and this is the language in the criminal rules, Florida Criminal Rules of Procedure, that I plead no contest to the charge as a plea of convenience while maintaining my innocence. And if the court accepts that plea, you get sent to jail. You can be adjudicated guilty, but you're not admitting it. Now, some judges will not accept pleas of no contest. That's in the discretion of the judge.
Okay.
And the only way they will accept it is if you admit on the record that you are admitting that there's a factual basis for the charge and that you are guilty. But it could still be the same plea deal, only without the no contest. And people still say, okay, in my heart, I believe I'm not guilty. Guilt is ultimately only determined by the jury. But you could plead guilty if the deal that you got was better than the risk that you would be undertaking to try to go forward and secure a judgment of acquittal by a jury verdict. And especially with the notoriety of that kind of defendant in today's day of mass media, of 24-hour news channels and talking heads, and these people who are color commentators who are expressing their strong opinions about cases. They're not newscasters. They're not the Walter Cronkites of the world anymore. They're the Nancy Graces.
They are. That's right. That's exactly right. Well
it almost makes me a little bit ill to say Walter Cronkite and Nancy Grace in the same sentence, and I suppose I should preface that in my opinion, so that if people choose to differ with me, that's fine. But there's a big difference between being a neutral newscaster and having an opinionated show. And there's nothing wrong with that. This is an opinionated show, because I do not hesitate, if I feel strongly about something, to share with our listeners in my opinion. Everybody's entitled to that, and everybody's entitled to disagree with that.
You demonstrate each week why people go to you when they have a legal issue. John, what's your phone number?
Our phone number is area code 352-547-4292. The law firm is Fuller & Fuller. If you have an issue in civil litigation, business litigation, Social Security disability, or a complex, complicated family law matter involving substantial issues, we'd be glad to talk with you.
Thank you, John. Call us here at the station if you need that phone number repeated. We'll take a little break and be right back. Thank you, John.
Ocala's information station, 1370 WOCA.
Ocala.
ABC News Now. I'm Karen Chase. For the first time in years, the public will hear from O.J. Simpson today when he testifies at a Las Vegas court hearing asking for a new trial. Simpson claims the lawyer in his first armed robbery trial failed to inform him about a potential plea deal before he went to prison. Jodi Arias may plead for her life in a Phoenix courtroom at her sentencing hearing. Jurors who convicted her of murdering her boyfriend begin weighing whether her sentence should be life or death. She has claimed she'd prefer death, calling it the ultimate freedom. Attorney General Eric Holder will likely field questions about the IRS and AP scandals when he testifies today at a congressional hearing. Airlines have been making big bucks charging all those extra fees. It totaled over